214 cases total out of the March cases that were dismissed and are pending.
Are you all going to try to re-indict those ones?
That decision is still pending.
And then, of course, to the April ones. So we understand there's like two crops here where some of them, I think it was 50-something.
We had 59 individuals who were still in jail, and those were our priority to address the individuals who were still in jail.
Okay. Those have been dismissed and then re-indicted?
Those were re-indicted under the courts. The district courts, well, the Council of Judges got together and came up with a new plan and a new procedure for indicting cases that were then ultimately certified to the misdemeanor courts. So the 59 were indicted and under the new procedure that the Council of Judges assigned for the district courts to certify those to the county courts.
Okay, and then the other 80, are you all considering dismissing those and re-indicting those as well, or what's the status of the other half of those?
They will be indicted as well.
Okay.
It just takes us a little while to get to all of those.
I see. So
they're just not as much of a priority because they're not in jail.
Oh, I see. So those ones have been dismissed then?
No, those are still
not.
pending.
Oh, those are still pending. Okay, do you know roughly when
Those are still in court. The judge has not granted a plea to the jurisdiction. In fact, he denied the plea to the jurisdiction on those in anticipation of our re-indicting those cases under the new procedure.
Okay, do you know roughly when that'll happen? Or do you have any?
Over the next couple of weeks.
A couple of weeks, okay. One thing we learned earlier today as well is the Public Defender's Office was saying that they've come to understand that there were actually like 4 different or multiple large group crossings rather than just one large blob during the April alleged border crossing. Is that your all's understanding, or
No.
what would you
Look,
say?
as I've said on numerous occasions, there are small groups of people that cross that are not in violation of Texas law. There are small groups of people, 5, 10, 20 people that cross almost every day, but they're not doing it in violation of Texas law. So those people, the National Guard and the DPS, literally every day are taking those people and are holding them in a holding area for Border Patrol to come and pick up and process under the laws of the federal government. The only cases that are being prosecuted by the state of Texas are those cases where they are violating Texas law, and that involved this one case, the violent riot cases that occurred on March 21st and April 12th, those 2 cases. So if there were other incidents where migrants were getting underneath or getting through the concertina wire and the fencing, they did it in such a way that was not in a riotous way. They weren't doing it in a way that endangered lives or in a way that allowed DPS to target who was actually cutting the wire and what group of people were taking advantage of that. There have been arrests for criminal mischief on individuals that they have been able to catch cutting the wire, but that did not involve groups of people in a more violent way attacking the wire and attacking the fencing. There was only one riot that occurred on April 21st and on March 21st and April 12th. Only one riot each of those 2 days. There weren't multiple riots and that got turned back or such things. It's only one riot each of those days.
One of the other questions that got brought up during the hearing was the Public Defender's Office was also saying that the Chief Public Defender doesn't have access to the portal and that she didn't want to sign an agreement. Are you able to describe the agreement in any way, and of course,
sure. So look, every single criminal defense attorney in town And the majority of the public defenders in her office have agreed to abide by the rules that we have for access to the case portal system that we have. The fact that Ms. Childress refuses to is on her. That has nothing to do with what every single defense attorney in town and the vast majority of the defense attorneys in her office do, which is agree to abide by the rules. And the rules are very simple. You agree that you're not going to share private information, which is related in these cases. We have private information regarding victims that are on those cases, private information regarding witnesses in those cases. We are putting information from police reports available for defense attorneys to see in order to defend their clients. This is what the law requires us to do, make this information available. So we do. We make this information available, but we require the defense attorneys to do what? Agree that they're not going to disclose it, which, by the way, is also required under the Code of Criminal Procedure. So all we're doing is asking them to agree to follow the law. And she's refusing to agree to follow the law, which is what we're asking her to agree to do.
What would you say to her? Because I remember, I think a little bit of that was said during court, and she said that, well, I go by the, whatever ethics board that attorneys answer to. What would you say to that response?
Then she should have no trouble agreeing to the agreement. If she's willing to abide by the law, if she's willing to agree by the Code of Ethics, then she should have no trouble saying, yes, I agree to this because that's what this is saying. I will follow the law, and I will agree to follow the law and abide by the Code of Ethics. That agreement asks for nothing more than for defense attorneys to be ethical and to follow the law. That's all it does. We're trying to protect the public and witnesses of crime and victims of crime from having their information disclosed. If they do disclose, if someone who has access to the case portal system discloses that information, we have an agreement that the attorney has signed that we can now go back and say, hey, defense attorney, you have violated the law, you have violated your ethics. We're going to limit or cut off your access to the case portal system. You, defense attorney, must now come down to our office and access the case portal information in our office in front of an attorney with one of our investigators looking over your shoulder, making sure that you're not copying down information that you're going to disclose illegally. All we're doing is saying, follow the law. And if she's refusing to do that, that's on her.
So what's the status right now with this issue? What's the status?
Well, apparently, judging from what she said in court, other people are violating, although she didn't name who they are, they're violating the agreement because they're letting her use their access to access this case. She clearly has been accessing the case because she started discussing what the evidence says. So someone in her office or someone is violating the agreement because although they signed the agreement saying they wouldn't allow someone else to use their access, she said in the hearing that she goes around and finds somebody else uses their access to access the evidence. She's supposed to come down to our office and review the case.
Your office mentioned that there was some kind of conflict over the public defender's office and just the different representation in the cases. Can you address that?
Sure. So the council of judges, when they assign the representation to the defense bar, right? They'll go down and for example, Derek Wyatt and Justin Underwood have a law firm, and in their law firm is Daniel Aguilar. So if the council of judges starts assigning people to different law firms, they recognize that there's a conflict of interest between Justin Underwood and Daniel Aguilar if both of them represent co-defendants on a case, right? So if they represent co-defendants on a case, those attorneys either have to get waivers from the people they both represent, saying, I recognize that I'm a co-defendant with this guy, and yet we have attorneys in the same firm. Attorneys in the same firm, by law, they share information. Right? That's the way it works if you're in a law firm. They share information, they talk to each other. So if I'm representing, if I'm a defendant with this guy, we're both defendants and we both have attorneys out of the same firm, we either have to waive that conflict or the court has to have a hearing about it, because we have if it comes down to trial, there's a potential that I, as a defendant, may end up testifying, hey, I have a deal to get lower sentence or something if I testify that this guy did the crime and I didn't, or this guy's more culpable and I'm less culpable. That's where the conflict exists. This guy was cutting the fence, or this guy was punching the National Guardsman and I did not. That incentive to point the finger at your co-defendant exists in every case. If you represent, and the Public Defender's Office is not unique, it's one big law firm. Well, the Public Defender's Office represents 20 people. Someone in that 20 people very well may be someone who assaulted a National Guardsman, who cut the wire. And the incentive of someone who was among that 20 who saw that to get on the stand and say, I should not be punished very harshly because I did not cut the wire. However, that guy over there did cut the wire. That guy over there did punch a National Guardsman. That incentive is very high because it's in their best interest to say that. Yet, as the attorney representing those 3 people, that attorney has a conflict because they represent the 2 people who are more culpable and the person who's less culpable. How can that be? They have a conflict. All 3 of those people should be waiving that conflict and saying, I realize that I'm less culpable than those 2 guys, but that's okay, I'm going to allow the same attorney to represent me. That's a problem. I think that's a problem. I think that's an ethical problem, and she either needs to have a waiver from each one of those clients or the court should be inquiring about it.
How many clients does she have?
I think she represents 26. I think that's the number. You've been trying to get in.
Yes, sir. Mr. Hicks, in regards to the just over a dozen migrants that were in court today, do you expect trial to start on Monday?
I would like to. I would really like to go to trial. I think the Public Defender's Office seems to be doing everything they can to avoid going to trial. They keep trying motions to quash that weren't heard today because they were filed today. They seem to be doing everything they can to keep from going to trial. We would like to go to trial. Let a jury decide what happens on these cases. That's all we've been asking. Bring a jury in from the public and let's talk about these cases.
And so I want to ask about that motion that you just mentioned, the motion to quash. You know, she talked about some of the accusations or some of the alleged conduct of her clients, the group of migrants that she was representing today, as intentionally vague, those accusations. What would you say to that? And does the district attorney's office need to be specific in the types of conduct that each person being charged allegedly partake in?
Yeah, so I don't know if she doesn't understand the law or if she's just trying to confuse and muddy the waters, which defense attorneys do all the time. I'm not sure. I mean, we track the statute. The indictment tracks the statute. And an indictment itself, the only thing an indictment is supposed to do is give notice to a defendant of what they've been charged with. The facts of the case, the discovery, flushes that out and tells them exactly what it is, the details, right? So the indictment just gives them the outline of what they've been charged with. The indictment tracks the statute, and that's what they needed. On this date, they were part of a group, which is 7 people or more, that participated in a criminal episode. And they knowingly participated, part of a group that was knowingly violating the law in the form of committing that criminal mischief. That's all that it takes to be a part of a riot. And all she needs to do is whip out the code book and read what the definition of riot is, and she knows, oh, look, that tracks the indictment.
One thing the judge brought up today was he seemed, he made a verbal comment about how the processing was handled, particularly when filing the cases. Would you be able to address that? I know these cases have been dismissed, re-indicted several times now.
So, yeah, again, you have to understand, this is not, the processing of the cases is not something the district attorney's office does. That's something that the district clerk the district courts do. And in this case, the Council of Judges created a specific procedure for how the district courts were going to certify and transfer cases to the county clerk's office, and then the county clerk's office, pursuant to the local rules, assigns those cases to a particular court. So this is something that's completely out of our hands. We take the cases to a grand jury, and after that, we give the true bill list to the clerk, and after that, it's out of our hands. So everything that he's complaining about is something that happened behind the scenes in the district clerk's office that goes to the county clerk's office. We don't have a hand in that. That's you know, I would suggest talking to the Council of Judges, to Judge Anna Pettis, who's the presiding judge. I think that they have a fantastic procedure in place, which goes, in my opinion, above and beyond what the law requires, as far as certifying and assigning the cases to the county court. Any issues that may have arisen, I think, have been rectified between the county district clerk and the county clerk's office. I understand he was concerned that an exhibit wasn't attached to the order. I think the clerk's office has been made aware of that. I think they have rectified that problem. But again, those are issues that are outside of our area of control. And again, I think the Council of Judges has gone above and beyond what the law actually requires to address what the Texas Constitution requires, which is the certification from district court to misdemeanor court.
So in this new system, is it likely then that, if you're a district court judge and you get, some kind of list from a grand jury from another district court, is this process
Well, so no, let me be clear. There's not, so if a case is indicted, it's never filed in a district court. A district court grand jury takes the case. It's never filed in a district court. It goes from a district court grand jury to the district clerk, who then certifies it to the county clerk. It never hits a district court. And I think that's something Ms. Childress doesn't understand regarding the law. She keeps thinking it should be filed in a district court. Cases from a grand jury are never filed in a district court. They go from, even if it's a felony, it goes from a district court grand jury to the district clerk's office, and then pursuant to the local rules are then assigned to the district courts and are then filed in the district courts if it's a felony. If it's a misdemeanor, it goes from the grand jury court to the district clerk's office, and then is assigned by the grand jury judge to the county court, where that's the certification process, and then the county court, pursuant to the local rules, in this case there's an assignment order, assigns it to the county court 7, or the local rules accordingly.
I know I've asked a lot of questions.
Yeah, you're getting some looks here.
This is my last one. Given that a lot of these are misdemeanors, they're going on their 60th day, having from the incident to now. It seems like a lot of work for misdemeanors. Do you have any particular comment over just how this whole process has played out, and if you'll continue to pursue the March ones?
Yeah, all we have done is respond to the actions of the Public Defender's Office. We haven't, initially all we did was file the cases and start moving forward, and then everything we've done since then have been in response to actions taken by either the court or actions taken by the Public Defender's Office. So all we have ever sought is just to hold people accountable for their actions. And I don't think it's too much to ask that if somebody commits a crime in our community, that they're held accountable. That's all we've ever asked to do, is hold people accountable for their actions. We will continue to do that moving forward. That's what our job is. It's what I feel like I've been asked to do as the district attorney, is to hold people accountable for their actions when they commit crime in our community.
Have you gotten any assurances from the federal government on the original group of people, whether they're still around?
We've gotten no assurances from the federal government on whether they're still around, nor have we had any assurances from the federal government that they would even be willing to prosecute federally anyone involved in any of these incidents. Which, if they were willing to prosecute any of these people, maybe that might affect our willingness to move forward. But the federal government has not weighed in at all.
How does this affect the other trials? Or
Other misdemeanor trials?
Yeah, or other trials itself.
It doesn't affect our office's ability to move forward. Doesn't affect us. We have a prosecutor willing to move forward and try the cases. So it doesn't affect our ability to move forward. The time that Judge Judge Morales is devoting to it, I don't know if he's having to continue other cases in his court in order to address these. But we certainly haven't had a trial in Judge Morales' court lately, so that wouldn't, I don't know why. It's not that we have had a bunch of DWI trials back to back to back, and now we have only riot cases. So we haven't had a lot of trials in his court. So I don't know if he's having to continue other cases in order to address these, but we haven't had a lot of other trials.
Do you have a lot of misdemeanor trials?
But let me go back to the budget and tell you that I am extremely proud of both the staff and the board. We spent a lot of time on the budget. Mr. Kim has done a lot of work with the staff at the granular level, and I've done a lot of work with the board. I met with the board members individually. Then we met as a group twice, and then this last Monday, and some of you were here, we had an activity about how we aligned the values and the systems, and we prioritized things that were important to the staff and to the board, and they were very similar. So we have a lot of consensus. We also know that we have a vision is a dream with a deadline, and this deadline